Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Judge, presiding. All persons that have business before this court draw near, give attention and you will be heard. May God save the United States of America, the State of Florida, this honorable court. Thank you, seated.
Good morning, everybody. I've been introduced. My colleagues today on the bench, as you can see from the signs on the bench, are Judge Makar to my right, Judge Harris to my left. We have 3 cases on the docket this morning, but we're going to have a panel change, so we'll have a short recess right after the first case. The way our system works, we have little traffic lights up there for you to see. Green means you're good with your time. Yellow means for the appellant you're into your rebuttal time. Red means stop. And we really like it when you stop. If I see you're getting into your rebuttal time as the appellant, I'll try to let you know. But it's your time. You can use it however you want. The 20 minutes per side, that's what's showing on the clock. You don't get 20 plus 5 more for rebuttal. And for the appellant, please let me know if you want something other than 5 minutes. That's typically what we reserve. If you have a noisemaker like a telephone or a computer that's going to make noise, please put it on silent or vibrate because it's guaranteed to go off at exactly the wrong time. So with that, we'll have our first case, which is 25-2370, Staker and Bell versus JEA.
Good morning, Your Honors. Jordan Lipkanen for plaintiffs' appellants Kim Staker and Earl Bell. I'd like to reserve 5 minutes for rebuttal.
Okay.
This suit raises a simple question of statutory interpretation. It does not ask nor require that this court delve into the completely extraneous topics of rate-making, balancing JEA's charter and statutory duties, or opining on the value of solar. The sole issue before this court is whether JEA, acting in its proprietary capacity, unlawfully terminated its net metering program in violation of Section 366.91 Florida statutes.
So it's all about what does offset mean, right?
That's exactly right, Your Honor.
Okay.
And we would say that offset means a 100% offset. The statute is not modified in any way. We can turn to the definition. That's really at the heart of this. Net metering, this is 366.91 2D. Net metering means a metering and billing methodology whereby customer-owned renewable generation is allowed to offset the customer's electricity consumption on site. So offset there is not modified. It's not partially offset. It's not offset somewhat. And more importantly, it is not about offsetting
Counsel,
value.
it doesn't say offset entirely either. If it said offset entirely, you've got a pretty good case. It just says offset.
You're absolutely right. It does say offset. The legislature, I think, thought it was clear enough that they did not need to say completely offset. If you look just one definition before, in the definition for customer-owned renewable generation, this is 2C. That is defined as an electric generating system located on a customer's premises that is primarily intended to offset part or all of the customer's electricity requirements. That definition is important for 2 reasons. One, we're again talking about offsetting energy, not offsetting value, not offsetting money, not crediting, but offsetting energy. And 2, the legislature saw fit there to specify all or part, and they did not just one definition later when they said that it means offset with no modification.
Well, D actually focuses on electricity consumption, correct? It's an offset of the consumption.
Well, they're 2 sides of the same coin. So C is talking about the equipment that allows you to generate the electricity that is offsetting your consumption. D is talking about net metering as the methodology that has been selected by the statute that the utilities are tasked with developing a program to implement, but specifically not just any program, but a net metering program. And it defines
so to simplify your argument, the offset means, well, in C it says offset part or all. So therefore you say because they didn't use the phrase part or all in D, therefore it must mean all.
Yes, that's right.
Okay.
So maybe to help understand this better, offset is not modified by the statute, so we give it its plain meaning. And the plain meaning of offset is to balance to make it, to counterbalance, to make it so there's no great result or no great difference in the result, to balance one opposing influence as to the other. The idea here is that offset means like for like, and under net metering, you are supposed to be offsetting energy. That means that every kilowatt hour of electricity that is generated by a rooftop solar system should, on a one-for-one basis, offset electricity from the grid. The reason we say it has to be one-for-one, even though it does not say one-for-one expressly in the statute, is because it's talking about energy. So under the exact net metering program that other utilities offer and that JEA used to offer before 2018, a kilowatt hour of electricity that came from a rooftop solar system was credited at the retail rate, which means when you take a kilowatt hour from JEA system, you pay the retail rate, and when you send a kilowatt hour to JEA system, you pay the retail rate. Because it's the same exact rate, now you're offsetting energy rather than offsetting money. The issue is that when JEA moved to offsetting, when JEA moved to end its net metering program and replace it with this new scheme where it credits at the fuel rate, now you are taking at 100% the cost of a kilowatt hour, and you are receiving, or you're taking from the grid at 100% the retail cost, and JEA is paying you at about a third of the retail cost. And so you can't say that it's offsetting, or that it's balancing out, that it's counterbalancing, that it's preventing some great difference in result, if you are getting 38 cents on the dollar and calling it a fair trade.
What was the retail, or what was the value of the retail rate for, say, calendar year 2025 or 2024? In other words, how much money are we talking about collectively at JEA between the retail rate for one particular year for everybody in JEA's jurisdiction versus the new fuel cost?
I would have to check that, but I want to be very clear that the retail rate is not challenged by any party in this case. My clients are not suggesting that the retail rate should be any higher or lower. They're not suggesting that the fuel rate should be.
They're happy with, they want that.
They want JEA to follow the statute, which requires JEA to credit them at the same rate that they are charging them for electricity taken from the grid. So
what percentage is it now? In other words, if they got the retail rate before, let's make that 100%, but now they're only getting the fuel cost. Is that like 40%?
The last time I checked, it was a little under 40. It hovers around a third. It basically has to do with whatever JEA is paying for fuel at a given time, and that is also what causes the retail rate. I think it's the thing that most influences the retail rate moving up and down from month to month. And the idea here is our clients are completely agnostic as to what the retail rate is and what the fuel rate is. In fact, we don't think it would be appropriate for our clients to challenge the monetary amount of the retail rate unless we thought that that independently was violating Florida statute. JEA has the discretion to set its retail rate where it wants to. The issue here is that JEA is trying to do what it cannot under Section 366.91, which is use a different rate. And that takes us out of a rate-making idea and into a rate structure idea, which is emphatically under the purview of this court to review.
What is the idea in 366.051 where they talk about a utility's full avoided costs? How does that factor into metering?
Yeah, that's an excellent question. So we use fuel cost and avoided cost as near synonyms, but that's not quite right. The fuel cost or the fuel rate is the predominant component of a utility's full avoided cost.
Because you could have a railroad car full of coal and you don't get any electricity, right?
That's right. You're also recognizing that there's a capacity cost, that there's other things that go into making the electricity. It's not just, if I give you a mountain of coal, you can make me some electrons. And so under statute, 366.051 defines that full avoided cost, and it gives some additional things to think about, such as an avoided unit. The idea of an avoided unit there is, this is the coal plant or the gas plant that JEA would have had to build, but for being able to get that electricity from a different source. So we're not taking specific issue. Well, we do, but it's not the focus of this case. The way JEA is defining...
That's pennies, basically, compared to 70% or 65% or whatever.
Well, I think the real issue that the fuel cost versus the avoided cost is very important for understanding here is if you look at the 2022 legislation that would have, for public utilities, phased out net metering completely and replaced it with a system that is almost identical to what JEA has, that talks about the avoided cost. But there's another one as well that talks about the avoided cost, and that's under 36691 subsection 4. This is a pre-existing duty that remains in place until this moment for JEA to purchase, not offset, not credit, but to purchase electricity from renewable generators at its full avoided cost rate. That is still in the statute. That does not conflict with net metering because it's for a different posture. That's more for qualified facilities under a PURPA idea. And the idea really is you can buy up 10 acres of land, slap up a bunch of solar panels, and JEA is required to buy that electricity from you. But they are only required to buy it from you at their avoided cost rate. When the legislature, 3 years after enacting that subsection, enacted the net metering subsection that applies to JEA, which is subsection 6 in 2008, that specifically says net metering, and it says offset energy, not credit value. And I think that's really what the center point of our case here is that when you hear JEA talk about these fairness arguments, what really goes into their cost, the fixed versus the variable, I would like to state very emphatically for the record that these are not uncontested facts. We have contested those facts in an affidavit by our witness, our expert, Carl Rabago. But the disagreement on those facts is completely immaterial to the actual issue at hand here, because all of that goes to value. JEA can determine that the value to it of a kilowatt hour of energy received from a rooftop solar unit is only worth the energy cost that it's offsetting. That's up to JEA. But the problem is that when JEA then says we're only going to pay you for what we think the value of that kilowatt hour is, now they're violating the statute, because the statute does not traffic in terms of offsetting value. It traffics in terms of offsetting energy. And so if JEA wants to pursue a system where they are compensating rooftop solar customers for the value to JEA's system that they perceive it to be, that requires a rewrite of the statute. And that is exactly what happened in 2022 when the investor-owned utilities went to the Florida legislature and they tried to get rid of net metering for their utilities.
That's the legislative history of a statute that didn't get signed into law.
That is correct. It was not signed into law, Your Honor.
Let me just ask you this. It seems to me JEA is making an argument that customer-generated solar power became too popular. Too many people wanted to do it. Therefore, we have an excess available to us, and that's why we had to cut back on the price we were reimbursing people. That seems to kind of run through their brief and through some of their argument. If there weren't as much customer-generated solar power being sold to JEA, was there anything in the record about how much additional capacity they would have to have in terms of additional generation, additional buildings to store the generators, additional employees and all that, in terms of what their non-fuel cost would have to be, but for the solar power coming from customers?
It's an excellent question, Your Honor. No, there is nothing in the record to this point, and that is exactly because both JEA and the appellants in this case agreed from the outset that the only factual things that mattered here were, are the clients that we are representing JEA customers? Did they install rooftop solar systems? Are they interconnected with JEA's grid? And is JEA compensating their excess solar capacity or their excess solar generation at the fuel rate rather than the retail rate? The answer to all of those questions is yes. That's the end of the material facts. And so when I talk about these other things that we are contesting, they're not material to the record. So neither party saw the need to go through rigorous discovery to develop a factual evidentiary basis for what the value should be, because again, we go right back to the statute, which says offset energy. And so it doesn't matter what the value to JEA's system would be. I recognize that the 2022 legislation, while it was fully passed by both houses, was vetoed by the governor, and we celebrate that decision because we think the governor got it right there, that we shouldn't get rid of net metering. But that was exactly what the legislature was trying to do, was to take on the exact kind of arguments that JEA is raising here. Those are completely appropriate arguments for JEA to make, just not in this forum. JEA's recourse is with the legislature, not with the courts, and not with self-help.
Do you see that as a credit for excess generation? Is that what you call what the legislature was trying to do that got vetoed by the governor?
The 2022 legislation?
Yes.
Yes, and in fact, if you look at some of the sponsor statements, all the sponsors in both houses are very clear that the status quo ante, when they were introducing that legislation, was that you had to compensate at the full retail rate. I can give you quotes if that's helpful, but You can also take on representation. That's what they were all saying. And this was clear in the staff analysis. It was clear in everyone that understood. It was clear at that time that that was the issue that they were trying to address. And you've got sponsors making statements about the value of the solar energy and it being too high because it's not taking into account these capacity costs and the other fixed things, the exact arguments that JEA is making. That is why the legislature was undertaking to change the statute, because they believed those same arguments. That's the appropriate form. If JEA wants to also have net metering go away for it, that's the place where it has to go. But what it's doing now is asking you to redefine the statute. It does not say 100% offset because the legislature did not feel that they needed to specify that offset. It certainly doesn't say any offset.
JEA also makes the argument that the rates have to be fair, just, non-discriminatory, and about 5 other different words. And they're saying that because most customers with solar generation panels are affluent, therefore the poor are having to prop up the rich in terms of this. Does that come into play in the statute at all?
Frankly, Your Honor,
whether it's true or not?
So there's 2 questions there. Let me take those separately. Your second question, is that in the statute? No, that's not in the statute. The statute just says provide net metering. It doesn't say provide net metering until you decide that it is economically disadvantageous or that it's creating problems for your utility. In fact, there are things in the statute that make clear that this is meant to go on in perpetuity, such as filing an annual report on the net metering energy that you've net metered over the past year, total participation, et cetera. But you can also look right at the first subsection of this statute that says the purpose, the whole point of 36691 is the legislature saying we want to see more solar on the grid, and we have designated net metering as the way to incentivize it. So to the extent that JEA is upset that the statute is functioning as intended, again, that's a question for the legislature to say, hey, it seems to have done what you wanted to do, now we would like to change it. But that, again, is not appropriately put to this court. And to the first aspect of that question, going to, I apologize, could you redirect me to the beginning of that? Or
that's all right. You're into your rebuttal time. If you want to
I'll save what
ponder it
remains.
or have your colleague there remind you what the question is, that'll be fine.
Thank you very much.
Thank you.
Good morning, Your Honors. Laura Beckman on behalf of JEA. JEA is complying with the statutory requirements of 366.91 because it developed a developed a net metering program for customer-owned renewable generation. This statute provides JEA with the discretion for how to develop that program, but that discretion does not make it ambiguous. The clear statutory language of 366.91 allows JEA to determine how best to reimburse customers for the energy that it takes. There's nothing in 366.91 that addresses the fuel rate versus the retail rate. Those words do not appear in this statute.
Under 36691 2D, net metering refers to a metering and billing methodology. So when I think of billing, I think of money. Do you?
Yes, Your Honor.
Okay. So when it talks about offset the customer's electrical consumption and billing, you're talking about how much to reimburse or pay the customer or offset the customer's bill, right?
Correct.
In the subsection C just above that, as counsel pointed out here, and in its brief repeatedly, they use part or all in subsection C when they're talking about generation. They do not qualify it at all in subsection D. So how do you counter his argument that if it's not qualified, it must mean equally 100%, 1-to-1, whatever else you want to mean to back in the old days when it was full retail?
So first of all, there is nothing in the statute that says that offset means a 100% 1-to-1 reimbursement.
Well, if it didn't mean 1-to-1 or full offset, why does it have to be qualified in subsection C?
I think it goes back to subsection 6, which is really the part of the statute that we're dealing with here, which is the directive to the municipal electric utilities to develop a net metering program and for customer-owned renewable generation. So both the definition of 2C and 2D are incorporated into what JEA must do. And so I understand the point. They've said offset part or all in C, but not in D. But D still doesn't directly address whether that offset has to be a 1-to-1 or a 100%. And so it can offset part or all of the electricity requirements in C does not mean that net metering has to be a 100% offset on the billing as well.
Well, in the utility world, I mean, there can be various costs. You can have retail, whatever is on the bill. You can also look at the utility and say, well, we're going to charge the marginal cost. You know, as you produce more energy, it costs more. The marginal cost of doing so. You have the fixed cost of the plant and the marginal cost of fuel. Then you have average cost. You might have average variable costs. So there could be a number of different ways in the utility world, and here, like electrical utility, by which a utility prices its product, or determines, not just the pricing, but also determines the cost of its product. So I'm struggling, and I'm not sure where I'm leaning, but I don't see where the legislature has specified exactly what is to be done, and that we have to kind of infer, oh, it's all. I'm just not, there's nothing in the statute to me that jumps out and says, this is what the rate must be.
Well, and so I think, excuse me, if the legislature had intended JEA to have to do a 1-for-1 offset, it should have stated so.
Well, I think they're saying that if they produce energy, you've got to buy it, right?
And we do.
Right. Okay, so whatever amount, whether this is their normal monthly electric bill and they produce a lot of energy and they only have that much because they produced all this, you have to buy the extra that they've produced. But what if they go over? That was a question we were talking about behind the curtain earlier.
If they generate more than they use in a given month,
Yeah.
I mean, that would,
Would you buy that, or did you offset that?
so my understanding is that it happens like on a daily basis, that, you know, typically you generate more solar power during the middle of the day when the sun's out, and then you're pulling from the grid in the evening when there is no sun. And so I think at the end of the month, they net that and say, okay, how much did you use versus how much did you contribute? And I think as a general matter, you're using more than you're contributing, so that's why you still owe money at the end of the day. I'm not aware of a situation where they've completely subsidized all their own power use and had left over to send back to the grid.
Does JA have multi-part rates, meaning some utilities will have a rate that's very high during peak demand, where demand is very high. They'll have a higher rate. So if you want to use air conditioning in the afternoon, it's going to cost you. If you want to use it at 3 in the morning, it's not so bad. Is that something that JA uses?
Yes, that's my understanding, and that's, that goes again to rewarding the customers who focus on conservation, who run their dishwashers at night, who try not to use the electricity during the peak hours, that they get the lower rates. Not only should the legislature have to specifically tell JEA if they are supposed to be doing something other than what they're currently doing, the statute is silent as to whether it's the fuel rate or the retail rate. And that gives JEA the discretion for how best to implement this statute.
Let me ask you this, counsel. Before y'all changed your billing from full retail reimbursement to now fuel cost, has there been a change in the statute in terms of defining what offset is?
Not that I'm aware of, Your Honor.
Okay, so with the statute, in terms of that being the same, JEA started out saying it's 1-to-1, it's retail to retail. Nothing changed with the statute, but JEA said, as I mentioned before, there's so much of this solar power being sent to us, we can't continue to do it at retail 1-to-1, correct?
Correct.
But there's been no change in the statute. So how do you come up with two different meanings?
Because if we look at the statutory scheme as a whole, 366, multiple other provisions within 366 tell JEA that our rates have to be fair, reasonable, and non-discriminatory.
Okay, is it fair that the solar people, I call them solar, the consumers producing solar or generating solar power, as I asked counsel for the appellant, if there wasn't all this solar power, wouldn't JEA need more generators, more buildings, more people? So aren't those people, I mean, in your brief, you say they're getting an unfair free ride. Aren't they, in fact, subsidizing JEA's operation for everybody by, you don't have to have, whether it's 2 more or 20 more generators.
I would not say they're subsidizing, Your Honor. I'd say they're paying their fair share. So the extra energy.
But for the solar power, do you agree, and I don't know if it's in the record, but I mean, just common sense, you would agree, but for the solar power, y'all might need additional generation equipment?
It's not in the record, Your Honor, but I don't know that that's accurate because my understanding is that the solar power that's generated by customers who own solar is a very minuscule amount of energy that's actually contributed back to the grid.
Well, then why is it so deleterious to the budget of JEA that you won't be self-sustaining if you continue to pay it 1-to-1? That's part of the argument. You don't come right out and say that, but you say you have to be self-sustaining, which to me, I take that as a hint. We're paying too much out, we're going to go under, we can't be self-sustaining if we continue to do that.
Correct, Your Honor, because if we say $10 for a kilowatt hour, $77 of that $10 is JEA's cost for the infrastructure. But for JEA having that infrastructure in place, the excess energy that a solar power customer would generate would just go to waste. It wouldn't have any.
Talking about fuel cost, again, you got a railroad car full of fuel, whether it's diesel fuel, liquid propane, coal, whatever it is, you can sit there all day and look at it and it's not going to produce 1 kilowatt of hour, whereas something running does. There are maintenance costs for that, there's repair costs for that, there's replacement costs for that. Those are all incremental costs that JEA incurs every time it generates a kilowatt hour, yet y'all are reimbursing only for fuel.
But those costs exist whether we get the energy from the solar-powered customers or whether we generate it on our own. The solar-powered customers would not be able to use solar power but for the infrastructure that JEA provides them.
And you couldn't use the solar power but for the infrastructure that the customer has.
Correct, Your Honor.
But you're not willing to reimburse them for that, just your fuel.
Because they would not be able to send that fuel to JEA, and JEA would not be able to provide them with fuel during the nighttime when they can't use their solar power, but for that infrastructure. And that is what...
Counsel, the infrastructure you're talking about, we're talking about power lines, power poles, distribution networks, I mean, a massive amount of infrastructure.
Correct.
Right? Someone who produces solar power on the property, I'm not sure exactly what the unit looks like. I mean, it's a solar panel, I suppose, and it hooks into the grid. They don't have, what your point you're trying to make is that this overall massive infrastructure that JEA has is substantial.
Correct.
And it's a much larger portion of their overall budget compared to like the fuel.
Correct. I think it is also important to recognize that this statute regulates municipal-owned utilities, which is different than investor-owned utilities. The PSC has decided that investor-owned utilities must reimburse at the retail rate, and that does not apply to JEA.
Is there a statute that says that?
It's an administrative code rule.
Okay, so it's not in the statute, but so some.
Correct. It's not this statute.
So is it the
And so
Public Utilities Commission that sets that?
The Public Service Commission
Public
has
Service,
said that.
right, okay.
But again, that's investor-owned utilities who, by definition, are trying to make a profit. JEA is not in the business of making a profit. We are in the business of providing electricity and water to the citizens of Jacksonville. And so to do that, our budget has to balance. We don't have investors that we pay back at the end of the day. We need, our charter and 366 has told us that our rates need to be fair, reasonable, and non-discriminatory. And if we pay the solar-powered customers the retail rate, our other customers are going to have to subsidize that. And that would put us in violation of the other provisions of 366 and on our own city charter.
So that's unfair that they have to pay when they don't generate solar power?
It's unfair that the non-solar power customers would have to pay? Yes, Your Honor.
Why?
Because they do not... The solar power customers are getting the benefit of the grid without having to pay for it. And then the cost of that grid, the cost of maintaining the grid and the power
They
lines,
pay just like everybody else.
they being the solar power customers?
Only what they get reimbursed is what they're getting the, quote, free ride on, correct?
I'm sorry, Your Honor, I've lost the train. Are we talking about the solar powered or non-solar
Well,
powered?
you're saying it's unfair to the people who don't have solar power that you are reimbursing the people with solar power at a retail rate, correct?
Correct.
Okay. Why? Why is that unfair?
Because the solar-powered customers are getting the benefit of the energy without the cost of the infrastructure. So without the 70% cost of that fuel, that kilowatt hour,
So were y'all violating your JEA charter originally when you were doing one-to-one retail-to-retail rate?
I wouldn't say we were violating it, but when it was a de minimis amount, that it didn't have the impact that it does
I
now.
thought you said it still was a very, very low amount.
The record does not reflect how much, what percentage of
Fair enough.
energy that, so I don't want to misspeak, but it's having enough of an impact that it's causing the rates to be discriminatory at this point, because the solar power customers are not paying, if they are reimbursed at the retail rate, they do not have to incur the cost of the infrastructure of getting the energy from their home back to the grid and from the grid back to their home. That the other customers are having to subsidize that amount, and that's what makes it discriminatory.
Of course, if this is a pure statutory interpretation case, none of this matters.
I would agree
Right?
there.
I mean, we heard from the appellant that this had, all this stuff, all this noise about this and that, fairness.
So
It
I
doesn't
think-
matter because in their view, the statute says it's 100% retail rate, period. No, they're not acknowledging any flexibility in JEA's pricing or reimbursement or anything.
So I do think it does matter in terms of looking at the statutory scheme of 366 and how, whether a rate becomes unfair or unreasonable or discriminatory. So I agree, we should first look just to the plain language of 366.91, and that nowhere in it does it discuss retail versus fuel rate. It says that the rate can be offset part or all. Those terms are incorporated into what
Part or all, again, is generation. Is the customer generating just part of what they use? In other words, are they saving 10%, 20%? Or are they generating enough so they don't have to buy any or almost any from JEA? That's a whole different phrase. Part or all, I think, hurts you when you talk about the metering and the billing. Don't you agree, or no?
Well, I think even if we look at the definition of offset, though, offset does not mean 100%. I mean, there's lots of ways I can offset my tax burden.
You
by-
thought it meant offset, you thought offset meant 100% before, and the statute hadn't changed.
But if we look at the statutory scheme in its entirety, in terms of whether the rates have to be non-discriminatory, reasonable, and fair, it's not reasonable to interpret offset as being a one-to-one offset if it would then cause us, because of the growth of solar power, to have those rates not reflect the actual cost to JEA of what it costs to pull that energy from the solar-powered grid, from the solar-powered customers. It may be true that prior to 2018, when JEA was doing a one-to-one reimbursement, that it was so de minimis that it wasn't having the impact that it is now. Doesn't necessarily.
And you say that's not in the record.
What's not in the record is what percentage of JEA's electricity is pulled from solar-powered customers.
Do we know what the change is before JEA changed its program from 100% retail to fuel cost?
So in the record, we have the affidavit of Mr. McInall, who does testify
In
that.
the other case, okay.
Correct. And Mr. McInall does testify that prior to 2018, well, it was really prior to like 2017, that the one-to-one one-to-one retail rate had a de minimis impact on JEA. So we do know that, but then as solar power usage increased, which JEA fully supports solar power usage. I mean, JEA definitely wants more and more customers to use solar power because it relieves the burden on JEA's obligation to generate that electricity, but it has to be fair and reasonable. It can't do it at the expense of other customers who either can't or aren't able to generate power through solar and are still having to pay for that, the infrastructure. I mean, if we take it to an extreme, if all of JEA's customers went to solar and they were all being reimbursed at the retail rate, who would be paying for the infrastructure? There would be no one left.
You want to talk about taking it to the extreme, you could reimburse solar customers at any rate you want from your argument, can't you?
No, Your Honor, because our rates still have to be fair, reasonable, and non-discriminatory. So JEA's board has to approve those rates, and the PSC ultimately has approval over our rate structure, not the rate amount, but the rate structure. So there are checks and balances that would prevent JEA from reimbursing for 1 cent at the kilowatt hour. And JEA has, we know from Mr. McInall's affidavit, has invested considerable time in determining what that fair and just rate is. How much of the kilowatt hour is consumed by the grid and the infrastructure versus how much of that is actually in the cost of the fuel itself.
Are there any other municipalities or rural electric cooperatives that have this program? I assume there are in the state of Florida?
Yes, Your Honor, my understanding is most of them are, that this is a bellwether case.
Okay, well, that was my next question, which is, I mean, how important is this case to all of them?
It's being very closely watched by the other municipalities because, Orlando, for example, is doing the same thing. I think this case was brought against JEA because, as the appellants identify in their brief, we are the largest municipally owned electric company in the state. And so it would have an impact not just on JEA, but all the other municipalities who are currently reimbursing at the fuel rate.
But this is the only case that you're aware of?
Yes, Your Honor. My understanding is this is the case that's going to test what rate has to be reimbursed at. And if I could just briefly address the quasi-legislative history of the attempted amendment in 2022, I think it's also important to keep in mind that that was driven by the investor-owned utilities who wanted to codify what JEA and other municipalities were doing because the rule that governed them under the PSC did not had the same language, but was interpreted by the PSC to not allow them to do that. Even though the statute was not amended, it's not even legislative history because it was never the amendment never passed. So instead, we're left with the plain language of the statute as it actually exists, which is silent as to any differentiation between fuel rate or retail rate. Instead, it gives JEA the discretion to develop a net metering program for customer-owned renewable generation that offsets the cost to the consumer, which is what JEA is doing. For these reasons, JEA asks that you affirm the decision of the trial court. Thank you.
All right, I was able to remember your question, and I'd like to start there because it really touches on a lot of what was just being discussed with opposing counsel. Fair, just, and reasonable. These are bedrock requirements of Chapter 366. They were enacted quite some time ago, in the 50s, 60s, 80s. The net metering statute is from 2005, amended in 2008. There was an earlier version in 2005, but really net metering comes from 2008. It's in the same chapter, and it is much more specific. It is a well-settled principle that if the legislature has a more general policy and a later, newer, more specific policy, to the extent that there is any conflict, the legislator intended the later, more specific one to control. However, we don't believe that there is any conflict. We don't think that there's anything that makes JEA's ability to provide rates at a full retail net metering unfair, unjust, or unreasonable. And to that, I would turn you to Florida Rising, Inc. v. Florida Public Service Commission. That's a Supreme Court case decided last year, where the Supreme Court signed off on a $2 billion transfer between different customer classes that was predicated specifically on enabling increased renewable generation on FPL's grid. I would also look at Clay Utilities Company versus City of Jacksonville. That's a case with JEA where they were charging higher rates for customers outside their municipal boundaries, and that was upheld, and the statute that did that was upheld as not violating the fair, just, and reasonable standard under 366 because it was enacted specifically to address a subset issue there that the legislature saw the need to address. And so that's what we're looking at here. The legislature wanted net metering to happen because they wanted there to be additional renewable energy. That does not create a conflict with JEA's general requirement to set fair, just, and reasonable rates. On the basis of the factual arguments about whether this makes it difficult for JEA to balance its budget, I mean, if you adopt JEA's argument, why not say we should just also exempt them from any environmental compliance, any labor and law compliance, I mean, anything that could make it more expensive for them to provide power. This is obviously not what the legislature intends when it says that it wants fair, just, and reasonable rates, and there's no reason to single out the net metering statute alone. On the there was a discussion where opposing counsel was talking about at the end of the month they net, and that is exactly what we have been trying to say the whole time. The whole point of this is that you are supposed to net, and you're supposed to net the energy. So if someone uses 1,000 kilowatt hours and they send 500 kilowatt hours back to the grid, you subtract the 500 from the 1,000, and then you charge them the retail rate, whatever the retail rate may be for that remainder. I mean, that's what the net is. And this makes sense. Net itself is not defined by the statute, so we give it its ordinary meaning. In net metering, we're talking about netting of a meter. If you talk about net income, you're talking about money in versus money out. If you talk about net job growth, you're talking about jobs created versus jobs lost. You're comparing these things on a one-for-one basis. That is just what that means.
Well, you want it to be 1-to-1, but there's other ratios. It could be 50% or 2-to-1. I mean, get back to your statutory. You don't have much time. Your reply so far has been about all this stuff that's not statutory. So to summarize, what's your strongest point on your statutory argument?
I mean, the strongest point is that net metering is talking about offsetting electricity consumption. And the only way that you can offset the consumption is if you are either crediting at the full retail rate, because then you're treating like for like, so you are having the effect of netting it out, or if you do the old school version of this, where they actually had a meter that ran in two directions. The reason that we even are having this conversation is that the modern version of the meter, you basically have a two-channel system, where you're measuring the energy that's coming in from JEA's grid, and you're measuring the energy that's going out. Net metering literally comes from a meter that would spin in both directions at the same exact rate. So kilowatt hours taken.
And then count down, right?
That's exactly right. And at the end of each month, you pay your customer charge, and then you pay the retail rate for the net number of kilowatt hours that you took from the grid. That's what it's meant in every state, the 37 plus states that have adopted net metering, and that's what it means in Florida. I think just to close out, JEA wants to offset value, but the legislature has made clear that it has to offset energy. So the value of 1 kilowatt hour of rooftop solar is a factual question that is just beyond the scope of this proceeding. If that were the issue, JEA could set it wherever they want to, but the legislature made that choice for JEA. They have to provide the full retail rate. Thank you.
Okay, thank you very much. And to both sides, very well briefed and very well argued. We're going to take a short recess, and then we will make our panel change.
All rise. United States of America, State of Florida, this honorable court. Please be seated.
Good morning. The second OA of the morning is Long versus Cruz, case number 2024-3450. Counsel for the appellant, would you like to reserve any time for rebuttal?
Good morning. Yes, Your Honor. 5 minutes for rebuttal. Thank you very much.
So noted. When you're ready.
Thank you. May it please the court, Andrew Harris on behalf of the appellant plaintiff here. This appeal on summary judgment, of course, de novo review presents a straightforward question. When in offer conditions, as the written offer here, a tender of 2 payments, bodily injury funds and diminished value check, when an offer requires a tender to a particular location, which it did here, the plaintiff's counsel's office, within a set amount of time, 30 days. If those conditions do not happen by that date, do you have a settlement? The trial court answered that question, yes. On rehearing, the trial court did indicate another court may disagree. We respectfully ask this court to reverse the trial court's finding of a settlement agreement.
What do you do with our case, ABC Liquors 2007 Fifth DCA case? I'll just read you a quote. What constitutes an essential term of a contract will vary widely according to the nature and complexity of each transaction and must be evaluated on a case-specific basis. Is that a fair statement of the law?
I do believe it's a fair statement of the law. There's, in certain situations, if the plaintiff's counsel had said that a check needed to be delivered that was blue and a check that was delivered which was aqua, is that an essential term of the contract that a check had been delivered in blue? I could make the case for it, but I could understand a court saying that the color of the check is not essential. But here the terms were essential. The tender had to be delivered, had to be to plaintiff's counsel's office within 30 days. The letter states
Counsel, does it actually say delivered anywhere in that letter?
No, you're absolutely correct on that. That's a colloquial misuse of the word. The letter says.
It would have been really good if it had said delivered for you, wouldn't it?
Yes, except.
I'm not saying you're going to give up on the other, but I mean, if it said delivered and they didn't deliver it.
The letter could have said. Yes, Your Honor. Could have said it had to be physically placed in the office by day 30. It would be a clearer case. But it does say tenders to our office. And so that is no different in reality. The funds were not delivered to the office. And what's important here, there is a suggestion in the answer brief that plaintiff's counsel did something wrong. There is no evidence, the trial court did not find. If there's an obstruction of tendering, of delivery, of production, that could be a different case. We saw that in the Lee case where the office was closed during a time when the offer was allowed to be made. We saw that in the Cullum case, another instance. There was an attempt to produce, an attempt to tender and deliver the funds. The office was not open at a time when it was supposed to be open. You have nothing here. Now, the defendant is correct that you look at the letter, there's 3 addresses on the letter, right? There's a Scrivener's error, which says tender to our office at Suite 200, the top of the letter, Suite 300, and there's a P.O. box. But none of that matters because all of those 3 were valid addresses and neither of the checks went to either of those addresses. In fact, the diminished value check, now yes, it's a smaller amount of money, but it's still a material term which said a check payable to, and it named the plaintiff. And the next sentence.
Is that a relevant part of the letter? That sentence, this check shall be made payable to the plaintiff, is that relevant? The reason I ask is when you quote the letter in your brief, you say the relevant part is this, and you leave that sentence out. Why?
Well, that was inadvertent in the initial brief, and I think opposing counsel, to her grace for me, acknowledged in the answer brief that that the initial brief later on goes to discuss that exact sentence. And so that was just an inadvertent copying from copying from the record on appeal over that, with a copy and paste. So that sentence certainly was not intended to not be in the initial brief. I do, of course, apologize for that. But the diminished value check shall be payable to Matthew Long. We will ensure that the funds are properly distributed. What the defendant did is, instead of tendering the check, the diminished value check, to the plaintiff's counsel's office, decided themselves to send the check to the plaintiff individually to his home address. As it is, they got the address wrong, and so the check ended up being sent back. But they took it upon themselves, as the recipient of a unilateral offer, to decide to send it to an address which is nowhere mentioned in the letter. And that sentence, "We will ensure that the funds are properly distributed," the fair and reasonable interpretation of that letter is that both of those checks are supposed to go to our office, which is the reference above. And so that is a decision, the trial court referred to where there was a good faith attempt here. No one's suggesting that the GEICO representative was in bad faith in sending the check to plaintiff's personal address, but they didn't complete the terms of acceptance of the contract. And I'm not aware of anything in the case law which says a good faith or bona fide attempt where you have a unilateral contract which requires acceptance and performance by a date certain. If you don't perform, you don't perform. There's not a meeting of the minds. And those are essential terms. And the trial court said, well, plaintiff's counsel was just a conduit for the diminished value check. And so what difference does it make whether it went to the plaintiff's address or attempted to go to the plaintiff's address?
Let me go back to the ABC Liquors case again, one of our decisions. Another sentence. A subsequent difference as to the construction of the contract does not affect the validity of the contract or indicate that the minds of the parties did not meet with respect thereto. Again, is that a fair statement of the law?
I believe so, yes.
So could that not be the situation here, that the GEICO's view of this and your view of this may have differed, but there could still be a meeting of the minds?
Well,
as to what you were just describing,
as to the location
payment, correct.
Well, ultimately, it doesn't matter because the check didn't arrive. This would be a harder case if the check had arrived at the plaintiff's house or apartment. It didn't arrive there.
Well, it was postmarked.
It was postmarked and it was sent. The bodily injury check, there's no proof that it actually was sent. I know there's business records, testimony, but in terms of the diminished value check, it was postmarked, it was sent. But I'm not aware of a case where performance, you must tender to our office by day 30. It was not.
Well, the cases are legion, though, about tendering, dropping it in the mail. I mean, you would agree, there are dozens and dozens of those cases, saying that that's a valid tender, correct?
There are cases, if it didn't say tender to our office, that could be a different story here. But the phrase tendering to our office by a date certain, there was not a tender to our office by day 30. There actually wasn't.
It was a tender by day 30, just not a tender to your office by day 30.
Well, a tender that, going back.
You're not disputing that, are you? That there was a tender here as to the diminished value check?
Well, tender requires actual production, right? And so it gets into, do you tender, if this had been sent to a cruise ship in Alaska, I know that's not the facts, right? But if this had been sent to a cruise ship in Alaska, would that be a tender? The fact that it went to the plaintiff's house here was not a term which was a part of the offer. The offer said you must tender to us, to plaintiff's counsel's office. It wasn't tendered to plaintiff's counsel's office. The fact that a very well-meaning representative testified, well, we're used to dealing with diminished value checks. We typically handle those with the person. We typically engage with them. In this case earlier, we engaged with them. All of that is an explanation for a good faith, and we didn't never subscribe bad faith, but good faith is not a tender when there's a condition there as to where the tenders, to get back to your question, the act of tender can mean different things depending on the course of dealings between the parties, the correspondence, the agreement. There can be a case where tender is in the mail. There's no question there's case law that allows for that under those case-specific circumstances. This unilateral offer did not say you can tender it, that's sending it in the mail with the condition to our office. That is the key distinction between these cases where merely saying, I accept in the mail, for example, bilateral contracts, I accept. That can be a contractual acceptance. I offered to buy your house for $100,000. I send an email, the person sends an email back, I accept. That's a contract, right? The mere email, or it could be sent in the mail, in the snail mail, so to speak. But here, the condition was tender to our office within 30 days. There was...
Counsel, the word tender means something short of delivery and receipt. I mean, you try to, and I think there's a case that says to make an effective tender, you have to actually attempt to pay, attempt to give the money, whatever else. And here, there was evidence, not crystal clear, that Geico did generate a physical check through their mailing branch or whatever you want to call it. It looked like they might have probably did mail it, so they actually took some step to make the payment to do what you asked. And it was you or whatever who chose to use the word tender rather than deliver. So under that circumstance, doesn't it appear that there was evidence the trial court could rely on in saying they did make a tender of both the BI and the diminished value checks?
I would respectfully say no, Your Honor, because the condition was the delivery, the place of delivery here was to our office. They never attempted to deliver the diminished value check to plaintiff's counsel's office. I would submit that the bodily injury attempt is not sufficient either because it had a date certain to arrive by day 30. But in order for
it appeared that they mailed it, and I can't remember exactly, but around April 14 or 15, and the time frame was to April 29 or 30, something like that. So
you're very close, yes.
Close enough for this,
Exactly.
right? So I mean, the evidence indicates that they mailed it a couple of weeks before the deadline. So they actually attempted to pay the sums due within the time frame, and we have no idea where the check went, but if things had gone according to normal, that check at least would have made it to the office, you would expect.
The bodily injury check, if it had been sent, but even if they could prove it had been sent and there had been a postal service problem, they made the decision there to not hand deliver. They made, I think in my opponent's answer brief, they're saying I'm raising a new argument by discussing the mail. I'm not saying they couldn't have mailed the checks. The offer did not require hand delivery. It did not require the Geico check, car to come. That is 100% true. But if you're going to take it upon yourself with a unilateral offer which requires performance to use the mail, this was their system, 500,000 pieces of mail a day. I understand that's a course of business. If you're going to take that risk upon yourself, you better darn sure make sure that it arrives by day 30. How do you do that here? The steps, there was no obstruction here. The step that they took was on day 30, and I don't fault defense counsel personally. This is not in any way. Defense counsel sent a letter to the effect of, please confirm that you have received the checks that have been received. That's on day 30. I don't know the time of the day.
Wasn't there on April 21st, and again, I may be off by a day or two, but around April 21st, wasn't there some correspondence from defense counsel to plaintiff's counsel saying, I understand they've already sent you the checks?
There was. That is true.
And the response that drew, well, and there was more to that saying, we're still working on the affidavits where it says basically the insureds have no money and no other insurance. And the only response from plaintiff's counsel was, well, what's taking so long on the affidavits? How about instead of that? We've already checked. We'll do this which will satisfy us instead, but nothing about, we haven't gotten the checks yet.
Right, but there's no obligation. There was no.
I agree, I'm not saying it's their obligation, but
A different set of facts. If plaintiff had received the check on April 22nd at their house, and plaintiff's counsel was aware of that, and the letter went to plaintiff's counsel, and plaintiff's counsel sat back, I wouldn't be here today. Because to me, that's not playing right, that's not playing fair. That's an affirmative misrepresentation. I wouldn't be here. But those are not the facts we have. We don't have any misrepresentation. We don't have any obstruction. We don't have any hindrance by plaintiff's counsel here. They didn't respond. With the April 21st, the letter said the checks have been sent, so, there wouldn't have necessarily been any reason to doubt that they hadn't been received. But the day 30 email, if they had had a conversation and if the record showed defense counsel called plaintiff's counsel up and said, have you received the check? And he misrepresented, I wouldn't be here today. Those are not the facts that we have. We have the email sent, and I'm not personally degrading defense counsel here in any way, but she sent an email saying the checks, it's my understanding the checks have been sent. He did not respond on day 30. I don't know if he received the email or paid attention to the email, but even if he did, it is not the offeror's obligation with a unilateral offer to tell the other side affirmatively.
again, if a tender is making the effort, actually doing something to try to send it, when there's evidence that looked like they mailed it or may have mailed it, defense counsel followed up on April 21st to the extent of saying, the checks have already been, I understand they've already been sent to you, not silent. I agree on day 30, sending a letter, not exactly belt and suspenders kind of stuff, but everything indicated that they had made that effort. And again, tender means something less than delivery and receipt. So
It does, but here the tender, and I know I'm just repeating myself, tender was to the office. That was it's a closer call, I would agree, on the bodily injury check from my perspective. But in order for reversal here, I don't have to show both. I have to be correct as to that one of the two was not complied with here, because there does have to be complete performance. And the diminished value check there was no attempt ever to send it to plaintiff's counsel's office here. That's undisputed. We know where it was sent. It was sent to the plaintiff's own apartment.
I don't mean to use up all your rebuttal time if you want to.
Oh, thank you very much. I will. Just very briefly, just because I don't want to say something new, it's not fair to opposing counsel. My second point has to do with the client consent issue. I'll just rest on and what I said in my papers with that, only very briefly. The issue of client authority, which was raised in an affidavit, which was raised at the hearing, and so I would contend that it is properly preserved. But if this court holds that what happened here was a tender of both of those, there was a lack of client authority because the client represented an affidavit that his understanding was that the funds would be received. And so that is an independent basis if this court concludes that there was an effective tender between the lawyers. I just want to briefly mention that, to be fair. Thank you very much, Your Honors.
May it please the court. Bretton Albrecht of Kubicki Draper on behalf of the defendants, Jennifer and Carlos Juarez. The trial court was correct. There is a settlement in this case, and the defense summary judgment should be affirmed. I'd like to just focus on a few main points and, of course, answer any questions the court may have. And the points are these. First, the terms of the offer. Second, the tender of the two checks. Third, the timeline, and then the client authority issue. And in there, I will be addressing the arguments that plaintiff made. First, the terms of the offer are very important. We understand that the demand letter required performance within 30 days. However, what were the material terms?
What about, though, the tender to counsel's office? That didn't happen here.
Your Honor, this demand...
You would agree that it didn't happen here?
With the diminished value check,
office.
The bodily injury check was properly addressed to the office. However, the diminished value check or property check was sent directly to the plaintiff's home address. So However, that's a very good question, and I did hear plaintiff's counsel say a number of times that the demand letter says that the checks are to be tendered to the office. The defense would submit that the offer does not actually say that. Those words are not in the demand letter. The demand says, as a pre-suit offer, we have been authorized to settle this claim for the full bodily injury policy limits of $15,000, along with $2,663 for the diminished value claim contingent on there being no, and it goes on, Your Honor, and we do quote it at length. It's several sentences down before you get to any addresses, and the address is connected only directly to providing the insurance disclosures. It says in the middle of the paragraph, and provide updated insurance disclosures pursuant to 627.4137 to our office. That's the only place in the letter it says to our office at the Suite 200 address. And I'd also...
There are several things in that sentence, other than just that last part. It says,
That's
if
correct,
you do this,
Your Honor.
this, and this.
There are, and...
Why are we ignoring the first part of the sentence?
So, well, I was trying not to read the demand letter that we had already quoted in our brief, but I think that also is a good point. Those other items were not mailed to plaintiff's office address, and plaintiff accepted performance of those terms. So that confirms that the actual where, as long as it was to plaintiff's attorney, the actual physical address of the tender was not a material term. And so for instance, the initial providing of the acceptance and proposed release on April 14th, that was mailed to plaintiff's P.O. Box, which is one of the 3 addresses on their demand letter. The insurance disclosure was provided by email twice. The affidavits of my clients, the insureds, were provided also by email.
Got there. The check.
That's correct.
The BI check didn't get there.
That's correct, Your
So
Honor.
they're not complaining about things they got, they're complaining about what they didn't get.
And I understand that, and I think that's where we come back to what is the meaning of a tender. But before we get to the details of tender, I just want to emphasize there are a lot of details that the demand was silent on. That does not make the demand ambiguous. In the defense position, it just means that those logistical details were a procedural formality, not an essential element. The silence just confirms that the terms plaintiff is now saying negate the settlement were not truly material terms. And the trial court found the actual receipt and delivery to plaintiff's office address were not material terms, and the trial court was correct.
What do you do, and again, this is, we could find this in any number of cases in Williston, probably, on contracts. I'm just going to read to you from Lunas, which is a second DCA case. An acceptance of an offer must be unconditional and identical with the terms of the offer. Do you agree the acceptance was identical with the terms of the offer?
It has to be identical on the material terms. That's
so
why
you would say this was identical with the material terms?
Yes, Your Honor, because the main term at issue is what's going to happen with the checks, and the checks were to be tendered. That term, tender, is very important because, as Judge Edwards has already recognized, the term tender means something short of delivery. This demand letter nowhere used the term receive, pay, delivery, did not use those terms at all, especially not regarding the checks. The checks are the key.
So you can tender something effectively to the wrong address?
Your Honor, there wasn't a wrong address issue here
I'm
at all.
talking about the diminished payment check. It
was sent to plaintiff's home address. It wasn't an incorrect address. It was just missing the apartment number. And if
So
plaintiff...
I just want to make sure I understand the position. So if you are told you need to send the check to a certain place, and you send it to a different place, but as long as you send it somewhere, that's tendering?
Your Honor, that's not what this demand letter said.
No, I'm asking something different. If you
If
send
it-
it to a different address than what's asked for, that wouldn't be tendering.
you send it to
You agree with me on that?
Yes, Your Honor.
Okay, so how is this different?
This is different because the demand did not specifically say tender to the office address. Also, we have to look at whether, we're not talking about sending this to Alaska. This is not a completely wrong address. It is sending it directly, the diminished value check, directly to the plaintiff's home address, missed the apartment number, and it brings us back to the definition of tender. As we argue in our answer brief, this demand required a tender, so we have to look at, well, what is a tender? A tender means actual production, issuance of the checks. There's no dispute over that. The question is whether that second part is met, a bona fide attempt to timely send or deliver the checks to plaintiffs or plaintiffs' counsel's office. Now, I understand that plaintiff argues that an attempt is insufficient to constitute a tender, but attempt is actually what makes a tender different than payment, receipt, or delivery. And we do cite a number of cases that stand for that position in our brief. The one that says it the most directly is the South Fork Investment Group case. And on page 79 of that decision, it says, to make an effective tender, debtor must actually attempt to pay the sums due. Mere offers are not enough. And that's what we had here. We have actual production of both checks, and although the facts of the attempted mailing for both checks are slightly different, the fact remains that both checks were attempted to be timely delivered. And that timeline is also very important because this was 2 weeks before the demand expired. GEICO said on behalf of the defendants, our insureds, we do accept on the same terms. We're working on the affidavits, and we will provide the check under separate cover. So, and I believe that the adjuster said that twice. So twice,
Well, it
2
didn't
weeks.
say we will provide, it says we have provided.
It does say
in
we
past
have
tense.
provided, and indeed on the 15th, the diminished value check was actually put in the mail, and there's substantial evidence of routine business practice that the bodily injury check also went into the mail on the 16th. Even though that couldn't be conclusively proven, that combination of the check actually being produced, issued, printed, and processed for mailing 2 weeks before this demand expired, that is the attempted delivery or attempted mailing, which we are arguing is sufficient to be a tender. And
Your GEICO representatives, when deposed, said they understood what they had to do was get the money in the plaintiff's lawyer's hands.
And the trial court addressed that at the summary judgment hearing, and he correctly noted that that is the legal definition of tender is a matter of law for the court. What a lay witness who's not an attorney's subjective understanding of what that means is not dispositive. And we've cited case law that tender means actual production plus a bona fide attempt to timely deliver. And that's exactly
So
what
all
was
this
done
meeting
here.
of the minds stuff really doesn't matter because there's,
It's a meeting of the minds on the essential terms. Here, the term demanded was a tender, and a tender is exactly what was done
the
here.
only minds probed were the two GEICO reps who said in the hand, right?
Well, Your Honor, again, a subjective understanding is not sufficient to change the objective meaning of the terms used
But
in the
again, I'm
demand letter.
saying, meeting of the minds. There's only
They
two
said
minds.
the same thing, Your Honor, and that's all that's required. They don't have to mean the same thing. The meeting of the minds is objectively, did they say the same thing, even if they may have subjectively had some slight differences on exactly what was required to meet the demand. I want to discuss the timeline here. We talked about when the two checks were issued, produced, and printed, and mailed or
What
processed.
do you do with the argument, and you heard it from counsel, there's a definitive deadline. You have the right to get it there any way you think best. You chose mail, and that's your right, but you do so at your own peril by not getting it there by the deadline. What do you do with that argument?
So my answer to that is actually twofold. The first part, you may not want to hear me repeat, but it all still goes back to that term tender. Tender does not mean actually pay, deliver, receive by the deadline. Tender means actual production plus an attempt to timely deliver, and that is what was done. The second part of my answer to that is if actual payment, delivery, receipt was a material term, number one, the demand would have said that. Those words are not in the demand, it only says tender. And number two, surely the plaintiff's lawyer would have answered and told us as defense counsel that they didn't receive the check. And that request was not just made on the last day before the demand expired. It wasn't just made, it was made on day 30, but it was made before that also. Again, 2 weeks before the demand expired, GEICO says, on behalf of the defendants, we accept the checks have been sent under separate cover. Indeed, the evidence shows that they were. 1 week before the demand expires, defense counsel reaches out to plaintiff's counsel by email on April 21st of 2021 and says, we understand that GEICO has already provided the checks. We're still working on the affidavits. Can we have an extension? In response to that, plaintiff's counsel did not say anything about not receiving the checks. Instead, he said, why do you need extension when there's still 7 days left on the demand deadline? There's a phone call the next day where they discuss the affidavits, and plaintiff agrees to modify what was required for the 2 affidavits, but still says nothing about having not received the checks. And that's why, we go to the last day before the demand expired, and the trial court is correct that this case is very analogous to the Lee versus Chmielewski situation, where we're trying to obtain confirmation. Have we done everything you asked to your satisfaction? Is there anything else that you want us to do? It's our understanding you already have the checks. If that's not correct, let us know immediately. And I know that plaintiffs...
Did you ever really ask that question?
Yes, Your Honor. I mean, different words were used, but it says...
Well, I think, and correct me if I'm wrong, I thought defense counsel on the 2 occasions said, in essence, I think GEICO's already sent the checks, or I understand they've already sent the checks.
In the April 21st email, that was the wording. In the April 28th letter...
You never asked, did you get them?
So that was what she was asking. If you don't have them, let us know immediately. In the April 28th letter sent by email.
That was the deadline day?
Yes, Your Honor. That was the one on the 30th day.
Was that letter sent by fax, email, or mail?
That was sent by email, Your Honor. So here, if it was a material term, they would have used deliver, pay, receive. They used the word tender instead. If it was a material term, surely they would have let the defense know that they hadn't received the checks. The case of Lee versus Chmielewski is, and I'll end with this point, Your Honor, Lee versus Chmielewski is very similar. Plaintiff questioned why the checks were not hand-delivered. It's because they were sent, issued, produced, sent for delivery 2 weeks before the demand deadline. In Chmielewski, it was a shorter deadline. It was only a 14-day demand deadline, and the offer was not accepted at all. Nothing was said about the offer until the last day. After business, the adjuster in that case for the liability insurance company, also GEICO, said, we accept, and then sent someone to hand deliver the check because they didn't accept until the last day. In this case, GEICO issued, produced, sent the checks 2 weeks in advance, and then started following up. I'm not suggesting that plaintiff had to respond. However, because he didn't, that combined with the fact that the offer said tender, not deliver, receive, pay, it must mean the actual receipt by day 30 was not truly a material term. The diminished value check, if plaintiff had actually received it, there would be no question that a settlement exists. So I think that also goes to show that the exact where, whether it was plaintiff's counsel's office or directly to plaintiff's home address, it was not an essential element. And that's exactly what the trial court found. The trial court found that under that definition of tender, that there was an actual production of the checks and a bona fide attempt to timely deliver it to the plaintiff, whether his attorney or directly to the plaintiff. Very briefly on the client authority issue, we're not saying that issue is not preserved. We're saying as a practical matter, the fact that plaintiff did not argue lack of client authority in their response to defendant's summary judgment motion, it's very telling. This was raised as an afterthought verbally only at the summary judgment hearing. If they had raised it sooner, perhaps this would have been an evidentiary hearing instead. But it wasn't until the summary judgment hearing 3 years after this lawsuit was filed that plaintiff first raised this lack of authority argument. And his only argument is that although he did authorize this offer in these amounts, he wanted the offer to say actual receipt of the checks within 30 days. Plaintiff's subjective intent about the words used in the offer does not negate the client authority that he gave his attorneys to make the offer in the first place. And Your Honor, they did file the lawsuit the day after the demand expired, so it was impossible for this to be corrected, especially before the demand deadline, when they did not tell us they didn't have the check. So for all those reasons and those further discussed in our answer brief, we are asking this court to affirm the final summary judgment for the defendants. Thank you, Your Honor.
Thank you. Rebuttal?
Thank you, Your Honors. The argument that the letter doesn't state the location of tender, I don't think is well taken. It says tenders and then to our office 4 lines later. The only reasonable place to have tendered the funds would have been to plaintiff's counsel's office. And in terms of the diminished value check, immediately after the sentence saying that the diminished value check shall be payable to the plaintiff, we will ensure that the funds are properly distributed and will handle all liens. So the only way that we will ensure that the funds are properly distributed would be if the funds were sent to the person who sent the letter, which was plaintiff's counsel. And so the representative's testimony about, it's one thing to say that the GEICO representative's testimony as to tender is a legal definition, but there's another part of their testimony which does go to this issue. Both of the representatives acknowledged that the location for the funds to be sent was plaintiff's counsel's office. That is a fact, which I think is the only reasonable interpretation of the letter. It was their attempt to perform was not identical. They did not comply with the material terms. As I said, it's a closer call with the bodily injury check where you have sent it or the business records show that there was an attempt to send it to plaintiff's counsel's office. The record is undisputed. They never attempted to send the diminished value check to plaintiff's counsel's office. That was a material term as reflected in the letter. It does have meaning for counsel to have the checks, to satisfy liens, to handle before there's any distribution of funds in a contingency fee case, you need a closing statement with your client. And so those were essential in material terms as to where the diminished value check was supposed to go. The Lee case, I know we addressed it in the briefs and briefly, the most important distinction is that in Lee, there was an attempt to bring the check during the time allowed under the offer. Here, there was never, for the diminished value check, an attempt to send it where the letter specified it was required. And so because there was not complete performance of all material terms, there was not a settlement between the parties within the time given. So we would respectfully ask this court to reverse and remand for further proceedings. If there are no questions, I thank you all for giving us the time today.
Thank you both. Before we call forward our next advocates, if you'd be kind enough to let them pack up, get out of the well of the court. Our next and final oral argument of the morning is Palmer versus State of Florida, case number 250287. Mr. Ufferman from Tallahassee, when you're ready. Rebuttal time?
5 minutes, Your Honor.
All right. Please proceed.
Thank you. May it please the court. Good morning. My name is Michael Ufferman, and I represent the appellant, Christopher Palmer. The sole issue in this case concerns whether the trial court erred by denying my client's timely motion to withdraw his plea. The argument in my client's motion was that he was affirmatively misadvised by his criminal defense attorney as to the impact of his criminal convictions on the pending or the civil suit that he wanted to pursue.
Counsel, can I make sure I understand? Your position basically is your client was promised by his lawyer that his plea to the misdemeanor level crimes would not impact his civil suit, his related civil suit against Geico, right?
Correct.
Okay. Yet during the plea colloquy, under oath, your client swore that he was not promised anything, and in the written plea agreement, your client, I'm assuming it's under oath, but it's not disputed, your client promised, or your client swore he had never been promised anything to get him to make this plea, correct?
Correct.
Okay.
So let me respond to that then.
Might as well, because that's what it's all about, isn't it?
Maybe. That's not really one of the three reasons that the trial court gave, but it is certainly an issue in this case. So regarding the plea colloquy, I submit that obviously that's a collateral consequence. And I submit that a fair interpretation of the question in any criminal plea colloquy is, have you been promised anything relating to the criminal case? And I say that for a couple of reasons. You could imagine a defense attorney saying, you know, as soon as we get out of here today, I promise you I'm going to buy you the best steak in town. Of course, if the question is asked, have you been promised anything, you wouldn't expect a criminal defendant to say, oh, my attorney promised me a steak. Let's make it a little more impactful. Let's say the attorney says, when this is over, you were on the police force and now you're going to get your job back. Or when this is over, you're finally going to be able to see your kids again. Those are all collateral consequences that you wouldn't expect a defendant to answer in response to that question. So I think that's one of the ways to distinguish it.
Also, there's so much testimony in the hearing transcript on the motion to withdraw the plea that your client always knew from, I want to say it was March 2023, but I could have that date wrong, whenever he dismissed his civil case, and I gather they were moving to dismiss because he wouldn't testify, wouldn't give a deposition, wouldn't come to court, whatever it was, and the only way around that was to take a voluntary dismissal. I get it. We've maybe not all been there, but we've been there. So he knew about this. This was not, what was he going to get to eat, something like this. He said in the hearing, I'm 100% innocent. I was never going to do anything but go to trial. My civil case depended on the outcome of the criminal case.
Yes.
So this is not, I get it, and I understand what you're saying. I don't disagree that the judge may be thinking, is anybody promising you to the sentence or that? I get that. But this is a guy where it's so central that even before he takes the plea, he's telling Martinez, look, this can't affect my civil case. This plea can't affect it. I promise you it won't. Anybody promise you anything? Nope.
Well, I think the same thing is true of the two main cases, three cases, I guess, that I've cited in my briefs, Chandler, Lundgren, and then Trenery. Chandler involved conditional release. There was promises made in Chandler regarding conditional release, and no statement during the plea colloquy in that case about, oh, he promised me something about conditional release, which is obviously what led to the request to vacate the plea. The same thing in Lundgren, first DCA case, that was game time. So I think these are things that are collateral and wouldn't necessarily come front to mind of a criminal defendant when being asked all these questions specifically about the criminal case? You're giving up your right to a trial, you're giving up your right to call witnesses. Has anyone promised you anything about this case? Again, I think a criminal defendant is going to interpret that, just as you indicated, Your Honor, that this relates to the sentence that I'm going to get as a result of this plea, or this relates to the 2 charges that are going to be downfiled from felonies to misdemeanors. The other thing is...
In the plea statement, though, no person has made any promises to me that induced me to enter this plea except those matters specifically set forth in this plea agreement. And again, I get it that the client's there, he's in court, all the rest of that, but if you look at this like any other contract, nobody made any promises to me about the punishment, the sentence, or anything to do with this case. Any promises. And clearly, your whole argument is Martinez made him a promise that induced him to do this plea.
So that's the standard plea colloquy.
I understand.
There's a number of cases that talk about general versus specific, and if a specific question is asked during the plea colloquy, then the defendant is obviously stuck with that answer, but general questions generally aren't going to cover this type of specific issue, number one. So clearly, if the question had been asked, whether the trial court was aware of it or not, but if the trial court had been aware of the civil case being an issue, oh, by the way, has anyone promised you anything about your civil case? By all means, if he said no, then I wouldn't be here today. I wouldn't have agreed to take this appeal. But the other aspect is the judge didn't make a finding on credibility on that. The judge made one credibility determination against my client, and that is that she doesn't believe he really would have not accepted the plea. And I'll address that in a second. But she doesn't dispute that Martinez really did tell my client this, and that's kind of what the plea colloquy goes to. So the idea that, oh, you said this in the plea colloquy, therefore it can't be true that something else was promised to you. I think everyone agrees the trial court certainly took it as a given that Martinez really did promise to my client that these misdemeanor pleas will have no impact on your civil case. So I think, again, when you look at the manifest injustice standard and interest of justice is always a consideration when there's a timely motion to withdraw a plea. The plea colloquy, the general question reasonably could have been interpreted as not covering collateral consequences, but more importantly, the trial court made no finding the promise was not made. So if I could then turn to, well...
How could they? The other guy in the conversation's dead.
True, but that's not my client's fault.
Well, no, I didn't say it was. but again, going back to the written plea, the law is it's contract, and in that contract it says, no person has made any promises to me that induced me to enter this plea. And that's exactly the argument you're making, that Martinez made a promise to him that induced him to enter into this plea.
But if that's true in Lundgren, when the first DCA said there was a promise made about gain time, and the defendant was allowed to withdraw his plea. That's true in Chandler when there was a promise made about whether the defendant would have conditional release. Those are, again, things that weren't brought up during the plea colloquy because I don't think that's on the front of a defendant's mind when being asked specific questions about, is there anything that's inducing you to enter this criminal plea regarding the charge you're going to have and the sentence you're going to have. I think that's when we talk about collateral versus non-collateral consequences. I think the plea colloquy, I understand it has broad language, but I think it can be reasonably interpreted to include the criminal sanctions at issue and doesn't address, or a reasonable person wouldn't necessarily interpret the question to mean that it includes all these collateral consequences, such as conditional release, such as gain time, such as the other issues that I gave, like you're going to be able to have contact with your child, you're going to get your job back. Those are all things that may be discussed that I don't think we would expect a reasonable criminal defendant to answer when being asked that question. They're being expected to answer, no, I was told that I'm only going to get 1 year probation, or I was told that if I didn't take this plea, my attorney was going to, sue me for money or was going to inflict some type of physical harm on me, and I was pressured into taking this plea. That's what the reason for the question, and I don't think the reason for the question would bring out any other collateral consequences that may have been discussed in the case. Again, the best examples I have of that are Lundgren and Chandler, which allowed those issues to move forward even though there was a plea colloquy in that case.
How do we know for sure that Mr. Martinez gave misadvice? Just the fact that the civil lawyer was no longer comfortable taking the case?
Well, my client's testimony is what establishes that.
that the civil lawyer wouldn't take the case, but there could be dozens who would take the case.
Oh, I'm sorry. So going to the prejudice issue, and I think the trial court misunderstood that. The trial court said, well, you're not prejudiced by his misadvice because you can still refile. But that's not the prejudice that's at issue. The prejudice is by entering the plea and having these two misdemeanors, which are crimes of dishonesty, that impacts the ability to move forward with the civil case. That's the misadvice. So yes, he could refile, but
Well,
that's a red herring.
That impacts this attorney's willingness to take the case, but maybe there are other attorneys, do we know anything in the record, other attorneys who say, I don't care about the misdemeanors, I'll take the case.
Well, this attorney told him having those crimes of dishonesty while you're trying to pursue this case against Geico is going to negatively impact your ability to win. And that's a fact. I mean, I don't think that's disputed. That obviously, if he's going to testify, regardless, Geico, I'm sure, is going to introduce the fact that he's been adjudicated guilty of crimes of dishonesty. That's going to have a negative impact on his case. And think of it in the context within which it was told to him. This is being sold as you're getting misdemeanors, not felonies. So initially, he's obviously charged with two very serious felonies, a second-degree felony and a third-degree felony.
And if he withdraws his plea in this case, he's back to facing the felonies, right?
Correct. Which further shows that the real reason he wants to withdraw his plea is not anything else other than he was given misadvice. So you could have a situation that a week after the plea, he violates probation. And now he's thinking, oh, I want to get out of that plea real quick so I don't have to face VOP consequences. We don't have that in this case. We have a situation where he was actually offered a 5 to 7 year probation offer earlier in the case. He rejected that.
Because he got a more favorable offer.
Well, no, but at the time, he wasn't sure he was going to get that more favorable offer. And it shows...
If we rule in your favor, can your client now refile that civil suit?
That's not apparent on the record, and I'm not a civil attorney, so I won't step out of my lane.
I mean, they kept talking about 5 years, the 5
Sure,
years hadn't
they
run,
did.
all the rest of it. But
I can't answer that question, and the record doesn't answer that question.
yeah, I didn't see it in there, but all I kept saying was the 5 years, and the 5 years is gone.
Sure, of course. So, wow, he could be taking a big risk by wanting to go forward here. This court grants
Because
relief.
all this, he could wind up, I know he didn't score prison time, but
He
they
could
were
get
talking about
20 years.
he could have been looking at big time. Also, he could have a suit that would be barred by the statute of
Correct.
limitations.
Yes, he understands that completely, but there's no other
Promise that? No, I'm just kidding. Go ahead.
There's no other explanation that would explain why he filed this motion other than what he said in his testimony. The very next day, he reached out to
San Sebastian or something close to
St.
that, right?
St. T's.
Santisebastian.
is what I thought it might be, but you were probably correct, Your Honor. He reached out to his civil attorney. His civil attorney said, wait a minute, this isn't going to work. This is going to negatively impact your civil case. And then one point I want to make, just to go back briefly. When explaining this to him, it really was explained in the context of, you're getting misdemeanors. And oh, by the way, I myself, this is Martinez, I had an issue with the Florida bar, that I was able to get my charge reduced down to a misdemeanor, and I kept my license because of it. So he's clearly telling my client that, oh, it's the fact that this is going to be reduced down to misdemeanors that you're going to be okay. That's not correct. And as soon as he learns out it's not correct, he takes the time. Can't happen overnight, but he goes out and gets another attorney, Mr. Roden. Mr. Roden puts together the motion timely to withdraw the plea, and that's why he's pursuing this motion to withdraw the plea. So to say that the reason the judge gave for the first reason for denying this is, the only credibility determination she made, I don't think he's credible when he says he really wouldn't have accepted this plea. It's because, you got the deal of the century. You were facing 20 years, and look, you now got it down to 2 misdemeanors and 2 years of probation. I don't really think you would have rejected the plea. Well, again, why else would he be filing the motion timely so quickly thereafter? Nothing has changed. The only possible reason it could be exactly what he said. And the fact that he previously rejected that 5 to 7 year probation officer further shows that, he didn't want felonies. He only wanted something that made it so he could move forward with the civil case, and he was told that these misdemeanors would allow him to do so. That was affirmative misadvice. And in the Chandler case, the second DCA specifically said affirmative misadvice, even about a collateral consequence of a plea, constitutes ineffective assistance of counsel. And obviously in the Lundgren case, the first DCA said a criminal defendant is entitled to reasonable reliance upon the representations of his counsel, and if he is misled by counsel as to the consequences of a plea, he should be permitted to withdraw his plea. Those two principles in the interest of justice apply in my client's case. All three of the reasons that the trial court gave are simply contrary to the record, not supported by CSE in the record. Regarding the second reason the trial court gave was, it was common sense that he would know that these pleas would affect his civil case. Well, wait a minute. I don't think it's such common sense. He's being told by his own attorney that his attorney had a bar issue, but when it got reduced to a misdemeanor, the whole bar issue went away. He's relying upon his attorney's advice. So, yeah, he has a right to rely upon that advice, as I just read. So, yes, he knew that there could be an impact from the criminal case on the civil case, but now he's being promised, I assure you, these misdemeanor convictions won't impact your civil case. The second reason the judge gave is erroneous. And again, the third reason goes to this idea that, yes, he can refile. That's not the prejudice. Of course he can still refile. The question is, are the misdemeanors going to have a negative impact on the civil case? And the answer is clearly yes. So for all those reasons, I'm asking this court to simply allow my client to go back to square one prior to the point where he got this improper advice. Yes, square one subjects him to both of these charges and up to 20 years in prison, and the judge will make a determination about whether or not the handwriting expert is admissible, and that may go against him, and that may hurt his defense at trial. But my client was affirmatively misled as to what would happen in this case based on his attorney's misadvice, or what would happen in what the impact would be on the civil case based on the plea result in this case. And the case law is crystal clear that a plea has to be voluntary, and this plea was not voluntary, and there's no evidence that refutes my client's claim. All the evidence in the record supports my client's claim. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Mr. Efferman. On behalf of the state.
Yes, Your Honors. Good morning. Zach Wiseman on behalf of the state of Florida. I have a few brief remarks prepared, but if the court obviously has any questions or concerns, just feel free to chime in. Just to address a few of the points that Mr. Efferman brought up, sort of the motivation for wanting to withdraw this plea. I think it bears mentioning that at the time that the motion was filed and at the time the evidentiary hearing was conducted a few months later, Mr. Palmer was still on probation. He was under the active effect of that sentence. Now, while the record seems pretty clear that he was doing good on probation, ultimately ends up terminating, I did want to address that point, that he still does have something to gain if he wants to go back to square one. I think that overall, there is some evidence that points to in the record and in his testimony at the evidentiary hearing that that perhaps there were other reasons for him wanting to enter a plea that day. There was great discussion about the motion in limine that the state had filed. It was seeking to basically exclude a handwriting expert, and it sounds like from what we can gather from the limited evidence contained in the record that Mr. Palmer's defense was very, very, very dependent on that expert's testimony to demonstrate that, I'm assuming he had been alleged to have forged some documents is part of this. And Mr. Palmer, in his testimony at the evidentiary hearing, he does say, I believe it's on page 285 of the record, regarding the motion in limine, he says that's why the plea was entered. And there's another point earlier in the testimony on direct where he says that the most important component of his defense was the expert. Just so to sort of paint a clear picture of the timeline, we're at jury selection. There's a motion in limine filed, I believe, the Friday before. Presumably they're there the following Monday. They begin to sort of hear the motion in limine. It sounds like it's going to go to some sort of Daubert hearing to determine whether or not the expert could properly testify. And during the intermission to that, they come to the plea agreement. Mr. Palmer pleads to the misdemeanors, and the rest is history. So we have a jury waiting, it appears. We have the motion in limine pending, and Mr. Palmer has made a great offer. I think probably everybody would agree that misdemeanor probation is a pretty good outcome. He ends up doing, I believe, 1 year out of a 2-year probation term, down from a second-degree and a third-degree felony, the potential of up to 20 years state prison. It was indicated at the plea hearing that he scored 28 points. He scored permissive prison. So the full brunt of potentially 20 years of prison and or probation is sort of staring him at the face, and there's a jury there ready. I want to bring up a couple points about sort of the fact-finding that the court engaged in and the testimony at the hearing. There's this idea that, according to Mr. Palmer's testimony, which unfortunately Mr. Martinez passed away, as Judge Edwards, as you pointed out, that's obviously not Mr. Palmer's fault, but there's this idea that they had this meeting, and we have the email. I believe it was in March of 2023, if I'm not mistaken. And the email's in the record where he says that, we had a meeting. He's basically memorializing that meeting with all the parties, where he's saying that everything is, intertwined, that these two matters are factually related. The allegation here is that he basically tried to, defraud Geico with a fraudulent insurance claim, and then he's trying to, I'm assuming, sue Geico for, basically not paying out that claim. Again, there's sort of limited information in the record, but I kind of understand that is, I'm assuming that is what's going on. There was a motion to dismiss, one with prejudice filed by Geico, where they had apparently proffered some evidence of fraud, and the court had set it for an evidentiary hearing a couple weeks later, and that's when Mr. Palmer agrees to voluntarily dismiss the suit. To me, it already sounds like, and I think that Mr. Santisteban, I believe is his last name, in his email is sort of pointing out that there are already issues with the civil case. He's concerned about it surviving a motion to dismiss. Mr. Palmer, mentions the conversation he had with Mr. Santisteban, or sort of the conversation as he recalled it and claimed it went down, is that Mr. Santisteban had basically told him, no juror is ever going to believe you. You're now a thief, right? Nobody's going to believe you. I think the idea that no juror would believe him when we were already concerned about maybe losing a motion to dismiss is...
Counsel, as of March 23, when they took the voluntary dismissal, is there something in the record that tells us exactly what their motion to dismiss was?
There is not. I can refer to the email briefly.
Well, I've seen the email, but I mean, it's like...
I don't believe we have a copy of the motion or court minutes or anything like that.
Right, so we don't know if they were getting it dismissed based on fraud, or if they were getting it dismissed because he was taking the fifth and wouldn't testify, right?
Right. I do know that Mr. Santisteban had indicated that someone from Mr. Palmer's camp would have to testify, most likely to survive the hearing, and that would probably have to end up being Mr. Palmer himself. So, but that's really the only indication we have. We don't know the subject matter of that hearing or
right. So
of
we
that
don't know
motion.
exactly what it was, what the nature of the problem was with the civil
Correct.
case. Once he's pled guilty and been adjudicated guilty of two counts of theft, then that is something that could come in during his testimony in a civil suit, correct?
I would assume so, especially in the context of, he's making admissions to a factually related case. I think that there's probably a couple of ways that can be used.
I mean, again, I don't think there's a real question about whether that could damage his case, whether he had a great case and now he had no case, or he had a crummy case and now it's even crummier. It still would impact his case, wouldn't you agree?
I would agree with that.
Okay.
I think
that's why he moved, according to appellant's counsel, that's why he moved to set aside his plea and no other reason.
That's correct. And that brings me to sort of my next point, which is the credibility of his statements at the hearing. I mentioned before briefly that he is still under the active sentence. Obviously he got off of probation. That's great for him. There was no indication that he was doing poorly, but he could still maybe not want to be on probation. I know he had agreed to pay some restitution as part of the plea offer. I don't believe that was to Geico. I think that was the Department of Financial Services, if I'm not mistaken. But there's sort of the idea that at the hearing, his testimony, he's talking about why he has waited so long to enter a plea, why he does it on Jury Monday. And he he mentioned several times, he says, something along the lines of, I'm 100% innocent. Why would I enter a plea? I was 100% innocent. And then we start getting into the expert was really important to my defense. And then we get into, the motion in limine. Well, that's why I entered the plea, is to, I take from that, and I think maybe the court was sort of alluding to this in the order, is, he sees that maybe his defense is not going to work out. If we kind of, and then going back to the actual plea colloquy in the plea form, as Your Honor pointed out, he affirmatively states he was promised nothing, he was not pressured, he was not coerced, nobody was forcing him to do it. The court finds, correctly at that time that he was entering the plea freely and voluntarily, and he understood what he was giving up. I think that in a situation where, Palmer brings up the monetary damages he's seeking, he says it's something over $200,000, I believe was the testimony in the civil suit. One point I certainly disagree with counsel on is that whether or not a reasonable person would have brought that up. I think that a reasonable person, if they were explicitly promised, this will not affect that, might have brought that up to the judge's attention.
Well, I agree with the word might. They may have, they may not. Again, I don't know how many times you've actually sat through a plea colloquy when somebody's...
I've sat through thousands.
Okay, well, great.
I was a trial attorney.
Well, then you know that sometimes you get the deer in the headlights kind of look from a defendant,
and I've seen that.
They may or may not really understand,
and I've also seen people who bring everything up, and it's it's a full-on 20-minute.
We don't really know here if Palmer was thinking, well, yeah, he told me my civil case would be okay because these are just misdemeanors like his drunk driving thing or whatever it was.
And I think again going back to his credibility is it's the timing of everything is, I think, casts doubt on the true motivation for wanting to withdraw the plea. Basically, he argues it would have, had he known it would have affected his civil suit, he would have never done it. But he's made a great offer at the 11th hour. There's a motion in limine pending that he might very well lose. I think, Attorney Martinez allegedly told him it was like a 50-50 or something of that nature. There's a jury sitting there. He knows full well that if the trial doesn't go his way, I'm sure he's been told at this point numerous times in court or by counsel that he could go to prison. It's certainly not outside the realm of possibility. I know fraud is something that's generally taken quite seriously at the trial level. And, I think that casts doubt on the credibility. And when we go, this is sort of brought up in the answer brief, we have to, not only determine the credibility of his statements, we have to determine prejudice, which in this context is essentially but for the misadvice, would he have elected to go to trial, and is that a reasonable decision? The factors are from our Supreme Court in Grosvenor, and they come to us from Hill v. Lockhart in the U.S. Supreme Court. Just getting those for you right now. But it's a totality of the circumstances test, and in determining whether or not it's a reasonable decision, you have to consider circumstances such as whether a particular defense was likely to succeed at trial, the colloquy between the defendant and the trial court at the time of the plea, and the difference between the sentence imposed under the plea and the maximum possible sentence the defendant faced at trial. So, working backwards, there's obviously a massive gulf between the sentence he got and the sentence he could have received. We have potentially 20 years versus 2 years of probation on misdemeanors, not on felonies. If he were convicted at trial, he would almost certainly be getting adjudicated guilty of the felony offenses, and he would have to live with the attendant consequences of that. The colloquy, again, there's no specific mention of this civil case or of the other sort of outside ramifications, but there is the generalized plea colloquy, and we do have the case law that tells us that you're bound by your answers in the plea colloquy. You're under oath. This is an agreement between you and either the court or the state. There's a finality interest here. We're resolving the case. This is a serious hearing, perhaps the most serious, assuming a case doesn't go to trial. And then we have whether or not the defense was likely to succeed at trial. And I think by Palmer's own admission at the hearing, he wasn't terribly confident with that motion in limine that he was going to succeed at trial. If that expert goes away, it sounds like it would have been an uphill battle from his understanding of it, from the attorney's understanding of it. And then just a few other kind of minor issues I wanted to point out was, the order denying the motion points out that the civil attorney, Mr. Santisteban, had said that he would consider refiling at a later date, depending on how the criminal case resolves. I don't see that as an affirmative promise that he would refile it. And then the other thing that I think sort of goes to his credibility in determining whether or not his true motivation was to pursue that civil case is he didn't talk to any other civil attorneys. He says that in the hearing that he just talks to Santisteban, and Santisteban apparently tells him, no, we're not going to do that anymore. This isn't going to work. The motion is filed a few weeks after the plea hearing. The evidentiary hearing happens, I believe, 4 months later. I think it happens in August, and the motion was filed in, I want to say, April. He doesn't talk to any other civil attorneys, and according to Palmer, there were over $200,000 in damages at stake. That was his understanding that he conveyed to the court at the evidentiary hearing, and he doesn't talk to any other attorneys. He just took what Santisteban told him and just sort of ran with it, and wanted to withdraw the plea. Didn't at any point, it sounds like, consult with another attorney about, like, hey, is this really that big of a deal? I think that would be a very reasonable thing to do if one were truly concerned about the civil suit primarily and was sort of willing to risk it all to pursue this. And he still had until, I believe, January of 2025 to refile the suit. And going back to the idea of whether or not he can even still do that, the short answer is I don't know off the top of my head. But according to Mr. Santisteban's email, if he was conveying accurate information, that period has passed, and I'm not so sure it would be told. And then the fact finding in the judge's order, she does, as counsel points out, she does find Mr. Palmer credible in at least one area. She finds that he did testify credibly that he had his civil attorney since 2019 and was aware that his criminal case was affected the civil case since March of 2023. The court believed that essentially strengthened her finding of the lack of credibility, that his statement that he would not enter the plea, she found that he affirmatively knew that his criminal case, which was factually intertwined, would affect his civil case. She finds him incredible in certain other areas. But I think that speaks to the court engaging with the testimony and with the exhibits and making a fair finding. The case law tends to give great deference to trial courts, and when they're sitting in a fact-finding role, the same as we do to a jury, they can consider the credibility of the statements and all manner of things. And I believe I've probably reached where I sort of prepared to address. Does any of the court have questions or comments? All right, well, thank you for your time. I ask that you affirm the denial of the motion to withdraw the plea, and thank you.
Rebuttal?
Thank you, Your Honor. May it please the court. I'm going to address a couple of quick points, and then I want to take another stab at the plea colloquy. I am just a simple lawyer from Tallahassee, but I'm not fully understanding the idea about, at the time he was facing 20 years in prison, and he was facing the judge potentially denying the motion or granting the state's motion limine and excluding his expert handwriting expert, and therefore that would have hurt his defense. So those are all the reasons why he wanted to enter the plea then. That's true, but if he wins this motion, all of that is back on the table. He's still facing 20 years. He's still facing 2 felonies. He still needs to have the judge rule on his motion, or the state's motion to exclude his expert, and he still could be found guilty after the trial. So that supports my client and his credibility that the real reason he's still facing all that, nevertheless wants to withdraw this plea because he was lied to. It was mentioned that the other benefit out of this is maybe he didn't want to be on probation. I submit, that in light of all the evidence in this record that's confirmed by an email from the civil attorney, that the real concern in this case was the civil case, that I don't think my client 2 days later woke up and said, I really don't want to be on probation. I got to come up with a reason to try to withdraw this plea. Let me use the civil case as an excuse. I just don't think that's what's happened here. And then finally, before I move on to the plea colloquy, I want to address what's said on page 285. This is my client's testimony. They're talking about the fact that the judge hadn't ruled on the state's motion in limine regarding the handwriting expert. And the question is, and you're aware of that when you entered the plea on April 8th, yes. So that was prior to entering the plea. That was prior to entering the plea because that's why the plea was entered. I don't think he's saying that's why I entered the plea. I think in context he's saying it was the question, the ambiguity about what the judge was going to do with the state's motion in limine that brought up the plea discussions that led to the plea. I don't think, if you look at the rest of my client's testimony in context, he's saying, clearly I entered the plea because I relied upon my attorney's advice that there be no impact on the civil case. Okay, let me turn to the plea colloquy. I think the most common way that courts are using plea colloquies, as they should, to shut down frivolous 3.850 claims is this. A defendant enters an open plea. The judge gets to decide what the sentence is. The judge may explain, or someone may put on the record what the minimum on the score sheet, or if there's a minimum mandatory, and what the maximum is. You understand, I'll decide that sentence. It'll be my discretion at the upcoming sentencing hearing. Has anyone promised you anything? No. Defendant gets the max. Defendant turns around, it gets into prison, gets to the law library, someone says, you should file a 3.850, your attorney promised you were only going to get 20 years. Of course, in that context, and I think that's the main context, that courts say, you can't go behind what you said. You said you weren't promised anything. And now you're complaining that your attorney promised you were only going to get 20 years, even though the judge says the sentence is up to me? That's a valid use of the plea colloquy to defeat a frivolous claim like that. And I know this court has seen hundreds of them. I've read about them in Florida Law Weekly all the time. I don't think it's meant in this situation when it's not clear-cut, it's not specific, and again, there is that line of cases that talk about specificity, and you need to be specific in order to defeat a specific claim. And the best example is, and I'll conclude with this, oftentimes the defendant says, my attorney failed to advise me about an immunity defense. But then they go back to the plea colloquy, and the plea colloquy said, did your attorney advise you about all available defenses? And the defendant, of course, said yes, but the courts allowed that claim to go through under the reasoning that the plea colloquy was not specific. It didn't specifically address the immunity defense, and therefore you're not precluded from raising that claim in a 3.850. So for those reasons, I'd ask this court to reverse the denial of my client's motion to withdraw his plea. Thank you.
Thank you, Mr. Ufferman. Thank you, Mr. Wiseman. Well presented on both sides. That's the end of our OAs this morning, so we're officially in recess.